Hi, I'm Shan Wu, and welcome to a Under Color of Law hot take about presidential immunity. Now, the Supreme Court heard arguments about whether a president has absolute immunity, which is what Trump has been arguing, absolute immunity for acts that happen while he's in office. Now, there's been a lot of legal commentary and a lot of in-the-weeds legal theory about this argument. And having listened to the entire Supreme Court argument, I can tell you that the argument itself was a wonderful example of really nerdy legal scholarship at work, but in a kind of disingenuous way, because all of that legal theory was hiding the ball that the conservative justices were using a lot of doctrine and complex structure to hide the fact that the real result they're going to reach is likely to at least delay the case, which will be very helpful to Trump. Now, Trump's lawyers tried to read the room with the conservative justices and how the argument was going, as they were arguing for a really extreme position that we're going to talk about. They also, though, signaled that they would be willing to ratchet back some on their extreme position so long as that resulted in a delay, because delay, of course, is still a win. But let me break down this concept for you about the absolute immunity. So let's start with the natural question of what is presidential immunity under the Constitution? What does the Constitution say about it? Very simple answer: nothing. The Constitution says nothing about a president being immune from anything. Now, there has been court precedent regarding civil liability for a president, particularly a sitting president while they're in office. So civil liability means people being sued for money, what they call civil damages. And the court precedent is that a suit cannot go forward against the president while they're in office. And if the lawsuits about what they call official acts, it really just can't ever go forward. The idea is we don't want presidents being bogged down in a constant barrage of civil suits that tries to second guess everything that they do. Now, that same idea for why you want immunity in civil suits is what the Trump lawyers are trying to extend into the criminal realm. Now, keep in mind, the Constitution says nothing about either criminal or civil, and there is not even any precedent regarding the criminal prosecution aspect. All you have to do to understand this is to take a look at just how Trump is trying to create out of whole cloth this notion of criminal immunity. So first, he's trying to use the same rationale as the civil immunity, meaning he claims that being subject to criminal prosecution would make the presidency unworkable, that a president would be so worried about being prosecuted for crimes that they'd be unable to function during the presidency. Now, as a matter of history, that's obviously wrong, since for the last 250-some years, we've not had a doctrine of criminal immunity, and presidents have somehow managed to still work, for better or for worse in some cases. But building from that supposed concern over being harassed or being so worried that you're paralyzed as the president is Trump's real legal argument that says that the core functions of the president, those are which are specifically delegated to the executive under the Constitution, those are the ones that are really important, that you can't be prosecuted for doing those core functions, because otherwise you couldn't do the core functions of the office. Now, what are some of these core functions? Well, for example, they include the appointment power. If you appoint someone to office, if you appoint people to become ambassadors, and of course, another core function is being commander-in-chief. Now, this last one, the commander-in-chief role, is really interesting because that really underlies the famous hypothetical question that was asked at the D.C. Circuit Court of Appeals argument. That's the one you may remember about SEAL Team 6. That question was asked by Judge Florence Pan, and that's a question that will no doubt go down in history. Full disclosure, Judge Pan, who I think is a great jurist, was a former colleague of mine at the U.S. Attorney's Office, and actually her parents were friends with my parents. But that does not affect my opinion of her very good analysis. And the question that she posed to the Trump lawyer at that appellate argument was, what if a president ordered SEAL Team 6 to assassinate a political rival? Would that also be immune from criminal prosecution? And the Trump lawyer hemmed and hawed at the time, but basically ended up saying that you still couldn't prosecute for that. They wanted to say unless that president had first been impeached and convicted in the impeachment. That's a real red herring argument because impeachment has nothing to do with a criminal prosecution. It's a purely political argument. Now, what's important about that for our understanding the immunity argument is that the commander-in-chief function is obviously very much part of the core duties for a president. And that's the point that Trump's argument is making. Really, however you use the commander-in-chief role, that's got to be free from any possibility of criminal prosecution. So a common sense reaction would be, how can that make any sense? How could you do these criminal acts? And that really goes to the heart of the problem with this extreme position being taken on presidential immunity. And I'm going to explain it in a way that not many people have explained it. And I think it wasn't really laid out during the arguments. If it had been laid out, I think it really would have better teed up just what the problem is. I think it wasn't laid out, not because no one else understands it, but because the conservative justices didn't want to really reveal this aspect. And the DOJ special counsel attorney was too lost in the weeds to really get into this point. By the way, that attorney is very, very skilled. He's a very experienced Supreme Court advocate. But as I said before, this whole argument in front of the Supreme Court was very much calculated, particularly by the young conservative justices, to lose the legal nerds in the weeds. And I think to some extent, that's what happened to the very able and experienced advocate arguing for DOJ. He was certainly facing a very manipulative conservative bench, so it was quite an uphill battle for him. So here is the real official acts immunity argument that Trump is trying to make, and a good, simple way to understand what the conservatives are trying to hide. Any action taken by the president that involves a power given under the Constitution excludes not only that power from criminal prosecution, but anything the president did with the power. Meaning, let's use the SEAL Team 6 idea. The president, as commander-in-chief, is certainly authorized to order SEAL Team 6 to do something because he's the commander-in-chief, they're military. So under this theory, anything he orders them to do is going to be immune from criminal liability because he has the authority to command the military. It's a core function. So you see how this creates the free pass for any crime you could order as president. You could tell SEAL Team 6 to assassinate political rivals, like Judge Pan's hypothetical. That assassination would have no legitimate, real military objective. You could also have them go rob a bank. Obviously, that has no military objective or purpose either. But the logic of the argument is because the president has the core authority to command the military, then anything he does through those commands is shielded by immunity. Let's take another example, the appointments power. The president has the power to make appointments, but one of the questions that's come up is, what if he was bribed for the appointment? Someone gave him money to make them a government official or an ambassador. The immunity argument says no criminal scrutiny is possible because he is authorized as president to make appointments. It doesn't matter that he's given money to make the appointments, that the appointment itself is a criminal bribe, quid pro quo. That aspect of the action, consequences, motivation, anything like that's completely shielded by the idea that he's allowed to make appointments. So here's some common sense interpretations or ways to think about that too. I'm allowed to walk down the street. That's my right. Can I punch somebody for no self-defense reasons? But my argument would be, hey, I'm allowed to walk down the street. So anything I do on the street comes under my right to walk down the street. Another analogy. We all have a First Amendment right to free speech. Now, of course, that doesn't include my right to walk into a bank, use my free speech to say, give me the money, I'm going to shoot you. That's robbery, bank robbery. But under the analogy for Trump's immune argument, the logic would be, since I have a First Amendment right to free speech, it doesn't matter what I do with that free speech. Anything that I do with it falls under the protection of the free speech. This is a obviously illogical and frankly immoral assertion of immunity. But that's what the conservative justices and frankly, even the non-conservative progressive justices were allowing to happen under this structure of debating what is a core function, what are official acts versus what might be private acts. So we're not really dealing with the fact that there's a deliberate effort by the progressive justices to undermine the law. But what happened was the conservative justices really wanted to focus on this idea of core official acts versus a private act. And they were asking questions, as did the progressive justices, about which of the charges here would be the private acts versus the official acts. So you can also sense here the sort of circular argument that happens because Trump's ability to point out that so long as he's president, pretty much anything he does is going to arise from his official duties. Therefore, the umbrella of immunity extends to pretty much everything that a president would do. It's actually really hard to imagine some kind of action that the president could undertake while president that wouldn't relate back to the fact that he's president. Remember the walking down the street analogy. He's walking down the street as president. He's serving his term. And everything that arises during that walk is protected. Now, during the oral arguments, the conservative justices, as well as progressive justices, didn't really take this head on. Instead, it devolved into a very theoretical legal argument with much of the discussion about which aspects of the charges brought by Jack Smith's office could be considered official acts versus private acts, with the idea that the private acts would not be the core functions of the president and they might be potentially criminally charged because they would fall outside the immunity. There was this particular exchange where one of Trump's lawyers was forced to admit that there were some acts that seemed completely private. For example, ones involved Trump speaking with his private attorneys. They weren't government attorneys, doing things, private attorneys like Rudy Giuliani's actions about the fake elector scheme. So take a listen to this one excerpt from that argument.
Go ahead. Go ahead.
So you concede that private acts don't get immunity.
We do.
Okay. So in the special counsel's brief on pages 46 and 47, he urges us, even if we were to decide or assume that there was some sort of immunity for official acts, that there were sufficient private acts in the indictment for the case to go back and the trial to begin immediately. And I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged. I mean, we dispute the allegation, but
Of
that
course.
sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That
Private.
also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's
Yeah.
private. I don't want to.
So those acts you would not dispute. Those were private, and you wouldn't raise a claim that they were official.
As characterized, what we would say, Your Honor, if I may, what we would say is official is things like meeting with the Department of Justice to deliberate about who's going to be the acting Attorney General of the United States.
Sure.
Communicating with the American public, communicating with Congress about matters of enormous
Thank you.
concern.
Thank you.
So one theory that arises from that discussion, sort of a plan B, is maybe Jack Smith could simply streamline the charges to only include these private actions. The actions that Trump's attorney concede are private, not official acts. And maybe that would make the Supreme Court ruling moot, so we could avoid this and get right to the case. So let's look at that for a moment as an alternative, because it has some problems. First, Jack Smith's team would still have to bring in the official acts, because otherwise it would be very hard to tell the entire story. They wouldn't have to charge the acts. They would come in for purposes such as showing intent and context rather than being the basis for the charges. That's known in law as an evidence issue of other crimes, other acts, meaning ones other than what are being charged. Sometimes those are also called other bad acts or other crimes. That kind of evidence has to be offered for things like intent or motive. And there could be a lot of litigation over whether it's really being offered for that purpose or not. And after the judge rules, there can be errors. So on appeal, that could cause a conviction to be overturned because the Court of Appeals decides the judge got it wrong. Example of that, Harvey Weinstein. Harvey Weinstein was just convicted and had his conviction reversed because the Court of Appeals said that the other bad acts that were let in, other assaults, other female victims, was too much of a prejudicial effect upon his case. So his conviction is being reversed. There's a lot of litigation about that. The trial court made rulings about it, but now the appellate court says, nope, you got it wrong, and that constitutes the reversal. So these kinds of issues can be very dangerous for the safety of the conviction. But we may not even get to that point because what the conservative justices are really trying to do is to fashion a very complex legal framework to manage this distinction between official acts and private acts. A distinction which we can see is really a mirage because there would be no real distinction if you recognize that there's immunity for official acts. But they want to create the distinction because it'll be really complicated. And they are clearly aware that they don't want to talk about the facts of this case. Justice Neil Gorsuch actually said, not interested in the facts of this case, we're writing for the ages. And that's very odd because a Supreme Court hearing should really be focused on the facts of the case in front of them. Frankly, that's a standard point appellate courts will make, which is, look, that's not the facts of this case. So let's focus on what's before us, not reach out to craft theoretical rules. But the advantage for them in creating a very complex legal framework is that will really gum things up. So here's the legal framework that it sounds like they're considering creating. They want the trial judge, Judge Tanya Chutkan, to likely make further findings of fact to clear up exactly which parts of the indictment are official acts versus private acts. So when you're hearing discussion in the media about whether the Supreme Court is going to remand, that means send back the case to the trial court, that's what they would do. They'd send it back to say, hey, we need more fact finding. We need to figure out what's really the official act here versus what's the non-official act. So the first problem, obviously, is the delay. Judge Chutkan can make those determinations, but the first thing that's going to have to happen is she's got to hold hearings about it. She makes a finding, those findings get appealed to the D.C. Circuit, and then from there, maybe back to the United States Supreme Court. So you can see how long that's going to take, a long time. It's already very difficult to get that case tried before the election. That would make it completely impossible, in my opinion. Second of all, that really requires a lot of small trials about whether this is an official act or a private act. The witnesses have to be put on, has to be a lot of evidence done about what exactly was happening when Trump maybe talked to Giuliani or when he made a speech, when he talked to Attorney General Bill Barr. These become a series of mini trials. And in order to do that for this case alone, that by itself really slows it down, much less putting this out there as a framework for any future trials, any future criminal prosecutions of a president or former president. Now, there's a silver lining to that, which is more of a political silver lining, which is if we have all these kinds of mini trials, all the potentially bad stuff is going to come out publicly because you have to put it on the record. You have to take testimony. And so maybe that may cause the voting public to learn about things that they would learn during a full criminal trial. But it's really a pretty thin silver lining in this case, because not only would it happen way too late to really help the election, but the people that really care about a conviction versus allegations and evidence coming out, that may be fictitious. We keep seeing these polls that there are voters on the fence who are going to say, oh, if there's a conviction, that's going to matter. So if that is true, this won't be a conviction. It'll just be a bunch of mini trials with information coming out. Very hard for the voting public to keep track of that. So I'm sorry to be so grim, but I do think it's important for us all to understand what is the real danger in this immunity argument that Trump's team is making, and why that argument, if it's accepted, is so dangerous. Now, in some ways, it's less dangerous than just the delay aspect, that the Supreme Court doesn't really do anything with the ultimate argument, but says send it back for this fact-finding. It's less dangerous because the idea of actually granting that sort of immunity, something that Justice Alito would want to do, would mean that once you're president, you can do anything that you want. That's the ultimate danger. And as Justice Ketanji Brown Jackson said, she really got to this point when she pushed back on Trump's attorneys saying, oh, if you allow criminal scrutiny, criminal prosecution, that would really hamstring the presidency. And what her point was, look, if there's no threat of criminal prosecution, she asked, what prevents the president from doing whatever he or she wants? And she said, quote, I'm trying to understand what is the disincentive from turning the Oval Office into the seat of criminal activity in this country. And that really does go to the heart of the danger of that immunity. What immunity really means is you can't look at it. You can't scrutinize the actions. And for me, that reminds me of this idea of sort of divine rulers, emperors, kings, that you can't even gaze upon them. And that's really what Trump wants. You can't even look at me with scrutiny without my permission because you don't have the authority to judge me at all. And that's really the gravest danger to our republic. And that's really what Trump enablers and supporters, including members of Congress, are trying to enable right now. Even if we never get a trial of Trump at the federal level before the election, getting this understanding out is really critical for voters, for us to understand what is the real threat with this kind of a doctrine. So thanks for listening. I hope that helped clear up this very dense legal discussion. And again, I really appreciate all the comments. I try to respond to them as soon as I can. Probably can't get to all of them, but I definitely am interested in hearing from you and getting more ideas for other topics to cover. So I'll talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.